welcome. We're here in the matter of State v. Richins. Can I start by asking the parties to enter their appearances?
Freya Johnson and Emily Adams for Corey Richins.
Marion Decker for the State of Utah.
Thank you.
Bryson King for Presiding Judge Scott.
Thank you. Just a couple of preliminaries before we get going. Is probably obvious to those who are in the courtroom. Chief Justice Matt Durant is not with us in person, but he is participating remotely. He will we'll just have to listen to see if he has a question for us, so we'll pay attention for that. I know we have experienced counsel with us who know the deal, but for those who might be here for the first time, those who might be listening in from home, we allow 20 minutes aside for argument, but our practice is to routinely allow parties to exceed that if the court has questions. What we ask is that the parties just continue to answer questions if they're being asked. You don't need to ask for additional time if you see your time has expired, but do ask that if there are no questions pending and your time has expired, that you please wrap up quickly and finish your argument. Would also ask those who are listening in and counsel to understand that that may result in one side having more time than the other. That's just a function of how many questions we have after reading the briefs and should not be seen as a reflection on how the court is leaning on the case. So with that, let's just clear up how our appellant's planning on splitting the time today.
If I can take 12 minutes and leave 3 minutes for the state and 5 minutes for rebuttal.
Okay, that works. Okay, with that, let's begin.
Ms. Richins and the State of Utah asked this court to reverse two rulings that were made in this case. The first is the presiding judge's order prohibiting in-person voir dire and jury selection. And the second is the assigned trial judge's order reconsidering its decision to expand the veneer to include residents of Salt Lake County. On the first order, the presiding judge in this case erred and abused her discretion by failing to give deference to the trial court's assessment of the facts and the specifics of this case and the extraordinary circumstances that merited in-person voir dire and jury selection in this case. The presiding judge in her amicus briefing makes the argument that the standing order gives her the power in the first instance to determine whether or not extraordinary circumstances exist. But the plain language of the standing order does not give that responsibility to the presiding judge. Instead, it makes the presiding judge's approval an additional factor along with the finding of extraordinary circumstances. And the rules that provide that the presiding judge's responsibilities in this respect are administrative and ministerial support interpreting the standing order to give the power to the assigned trial judge in the first instance to make a determination of whether case-specific factors warrant in-person voir dire.
Can you point to me the language in the standing order that you're relying on to say that the standing order gives that responsibility to the trial court?
It doesn't explicitly give it to the trial judge, but it doesn't give it to the presiding judge either. Instead, in the final line of the standing order, it states, absent extraordinary circumstances and prior approval from the presiding judge, all jury selection in the 3rd District Court will be conducted virtually. So it doesn't assign the presiding judge the responsibility of determining extraordinary circumstances, and reading the order in that way would be contrary to the Code of Judicial Administration and the Rules of Criminal Procedure, both of which assign the assigned trial judge the responsibility to make case-specific determinations and rulings, and the presiding judge the responsibility to make district-wide policy.
But you'll concede that there's no rule of criminal procedure that speaks to this specific question.
There isn't a rule that speaks quite to this specific question, but Rule 29C comes close, and that deals with change of venue. And that Rule 29C provides that if a fair and impartial jury can't be held in the court location where the action is pending, the party may move to have the trial of the case take place with a jury from another county. And in that case, it's the trial court that makes the decision. And similarly, Rule 17 and Rule 17.5 and 18 provide that the court has discretion to set an in-person hearing, a remote hearing, or a hybrid hearing. And then Rule 18, the judge shall determine the methods of selecting the jury.
So is there anything in 17.5 that you can point to that suggests that that rule speaks to jury selection?
It talks about hearings, so in-person hearings, and so I think that, that conveys that there refers to proceedings in the case that are being held officially. I don't think it specifically references jury selection or in-person voir dire, but when this rule was put into place, there wasn't a third district standing order creating kind of a separate standard for virtual proceedings in that context versus other contexts.
I actually think that this rule post-dated the standing order.
The third district?
The 17.5 came after the standing order.
The third district court standing order?
I believe so, because isn't that from 23?
You may be correct.
Okay.
Yeah, I apologize if I misspoke on that point. So I think that in this case, when the presiding judge has a responsibility under the rules, the court rules, it's spelled out. For instance, in 29B, dealing with motions to disqualify. If a party files a motion to disqualify, the court is required to refer that to a reviewing judge, which can be the presiding judge or another judge in the district. But that involvement of the presiding judge or another judge in the case is spelled out in the rules, whereas otherwise the trial judge is the one assigned to have the discretion to manage the proceedings in his case or her case and enter orders that are appropriate for the case over which it's governing.
On the language of the standing order, when it says prior approval, to me, that might suggest that the trial court, before making any kind of determination, needs prior approval from the presiding judge. Here we had a trial court who made its own finding, its own ruling, before getting prior approval with the presiding judge. Do you see that as a problem, and why not?
Well, Your Honor, the standing order is not comprehensive on what exceptional circumstances mean, what the presiding judge's approval is contingent on, or the process by which this could occur. So the extraordinary circumstances is listed first in the rule. It says extraordinary circumstances and the approval of the presiding judge. I think that conveys, at least that it was reasonable for the trial court to think it makes the determination of extraordinary circumstances and then seeks the approval of the presiding judge.
But it doesn't say absent a finding of extraordinary circumstances. It just says absent extraordinary circumstances and prior approval. I just wonder if that's actually creating a legal standard in terms of saying that you have to make some findings to support like a legal standard of extraordinary circumstances, or if it's just saying that it would be unusual for the presiding judge to give approval. That perhaps you'd have to have a situation where you have a county where, most of the jury pool doesn't have access to Wi-Fi or electronic devices to participate remotely, or some other kind of unusual thing that occurs. Is it possible that just means that the presumption, absent something unusual, is that it will be conducted virtually, and what really matters here is the prior approval from the presiding judge?
Well, I guess there's a few things to unpack there if I could. So I think first of all, the extraordinary circumstances may to some extent involve a legal determination, but it's at least a mixed question. It involves a factual assessment or an independent assessment of factors that are specific to the case. And the rules don't empower the presiding judge to have that level of involvement in another judge's cases. She does have responsibility, or he has responsibility over, policy making, calling meetings, budgeting, being the court's representative, these ministerial and administrative functions. But to independently evaluate whether extraordinary circumstances exist as a factual or legal matter in another judge's assigned case is outside the purview of the presiding judge's authority. So reading the standing order in that way would create a conflict with the responsibilities assigned to the respective judges under the Code of Judicial Administration.
Well, and I suppose my question does go to the authority of the presiding judge. Can a presiding judge, through a standing order, create a legal standard that has to be applied, or just a process, like an administrative process that has to be employed? I find it a little bit strange that we're here being asked to apply a legal standard, that what you see as a view as a legal standard, and what which the trial court did, and I think to some extent the presiding judge did in her order as well, that is essentially created by a standing order. Is that within a presiding judge's authority to create a legal standard that has to be met in a standing order? And I don't know the answer to this question. Truly, I'm not I'm curious what
Yeah.
your response is.
I don't think that answer is obvious from the rules. This seems to be a bit of an unprecedented question before this court. I think that the rules do provide that the presiding judge has authority to make district-wide policy and rules to facilitate operations. And to the extent the standing order is viewed in that respect, I think it's compatible with her responsibilities. Specifically, if it, allows the presiding judge essentially a ministerial role in deciding if the logistics are appropriate at that time to hold in-person voir dire, or for instance, if another court has in-person voir dire at the same time, maybe we need to reschedule, change courtrooms, the type of things that are within the judge's responsibilities to assign resources, courtroom assignments, things like that. But as far as establishing a legal standard, I don't believe that I was able to find anything that gives the presiding judge the authority to set a legal standard. Even assuming that the presiding judge could set a standard, there's still nothing in the rules of, the Code of Judicial Administration or the court rules that allows the presiding judge to make a case-specific evaluation of a case assigned to another judge.
What if, what if, for instance, the presiding judge said, we have so much media attention, we have so many people attending, we need to use a different courtroom that's larger? Mm-hmm. And the presiding judge said, no, that's not going to work, it's not available, whatever it is. Is that a case-specific determination that the presiding judge would have to defer to the trial judge on?
I don't think that it would be the way Your Honor has described it. I think if it's a question of reassigning courtrooms and so forth, that's within the purview of the presiding judge. But I don't believe that gives her the ability to say in-person proceedings aren't warranted in this case. I think that in her ministerial role, her administrative role, she could talk about the logistics of, no, we can't reassign courtrooms. You're going to have to find another way to deal with this. I think that's appropriate. But making a case-specific determination about whether extraordinary circumstances are present or in-person proceedings are warranted is just outside the scope of the presiding judge. So the standing order shouldn't be read to give her that authority.
How do you square, sorry, please go ahead.
So I have a question that the presiding judge asked in her order about how you envision, if you did do this in person, how you would envision the veneer being exposed to the circumstances that they would be exposed to in trial. Mm-hmm. And I'm lucky in this case because I did the criminal calendar in Summit. So I can envision the courtrooms up there, and I know where the parking lot is, and I know the building. And at this point, jury selection has changed so much that my memory of jury selection is very different than I'm sure what happens now. Mm-hmm. But in doing in-person jury selection, it seemed like the veneer took all of the seats in the gallery. Mm-hmm. So I guess if jurors were summoned in person and they came and they parked in the courthouse, they certainly would be in the crowded parking lot and they would see all of the people in the building, and mm-hmm. assuming that there is a lot of media and public interest even at the jury selection stage. So outside of the courtroom, they would certainly walk through it. But in the courtroom, wouldn't the gallery be filled with the veneer? Would it be kind of this packed courtroom with the energy that the judge described? Or how do you just logistically mm-hmm. Envision that playing out?
Yeah, well, I think that, okay, two responses to that. I think the first is that the Judge Mrazek, the assigned trial judge, noted that the media presence was prevalent throughout the courthouse. So in the parking lot, in the public areas, and for the potential veneer to come forward and to deal with that type of crowding in the courthouse, that type of presence is instructive, and it's the only way the parties can really assess if a party might be intimidated or thrown or distracted by those type of presences in the courthouse as a whole. But beyond that, the U.S. Supreme Court has held in cases from 1984 up to 2017 that the right to a public trial applies to voir dire and jury selection proceedings. So the press has a First Amendment right to be present. The defendant has a Sixth Amendment right to have open proceedings. And the court, to close in proceedings entirely under these Supreme Court precedent cases that I can give you the names if you're interested, but would have to determine that there's not a more narrow way of dealing with logistics like juror seating. So in one of these cases in particular, Presley v. Georgia, there was a situation where the judge had spread the veneer, the potential veneer throughout the courtroom, and then turned away other individuals, turned away, and I don't think it was the press in that particular case, but just turned away the public because there wasn't room. And the Supreme Court, the U.S. Supreme Court said that that essentially it's not just because the courtroom may be crowded is not per se a reason to close the proceedings. They would have to consider if other options are available. So here with a pool videographer, a pool photographer, there might be limited presence in the courtroom itself in light of the crowding concerns, but I don't think we can assume that we would be able to close the courtroom completely just because of crowding, given the First Amendment and Sixth Amendment rights at stake here.
I also wanted to make sure I understand the nature of your argument. So and this is such an unusual question, right? This is, I don't know that I've ever seen both sides at the same table. And the question of this line between whether it's an administrative role or making a legal decision is just very unique. And I want to make sure that I'm getting your argument on this. So, I realize you made a constitutional argument to the district court judge, which is not before us.
That's correct.
So right now, we don't have an argument about a legal right of the defendant. The presiding judge did not make any decision or order about a legal right of the defendant.
That's correct. She just determined that extraordinary circumstances weren't present here.
So it's basically whether the language in the standing order is met, but your argument is not. The defendant has a particular legal right that is at issue here, and if we don't get the in-person jury selection, that right is going to be impinged upon. There's not any legal argument about that.
Well, there's not a constitutional argument that virtual proceedings are unconstitutional or anything of that sort. But there is an argument that both parties have the interest in seating a fair and unbiased jury that can perform its duties without distraction, and that the presiding judge's interpretation of the standing order and application of the standing order interferes with the party's ability to seat a fair and unbiased jury under these circumstances.
And I understand the issue with potentially having a juror who is seated and can't handle the pressure in the courtroom and becomes distracted or is unable to really focus. Is that something that could be addressed with more alternates?
It's possible that more alternates might help in a situation like this, and I believe the trial judge is considering the appropriate number in such a complicated case. But I think that ultimately, whether we're talking about the alternates or the main jurors that are selected, the challenge is that without being able to evaluate the performance of the jurors in the courtroom and their own reaction, even jurors themselves may have difficulty ascertaining how they could perform under the circumstances. So we have a wide variety of case law, for instance, saying that jurors' bare assertions that they can follow the law, for instance, isn't enough to refute biases that has been shown by other questions. So a potential juror, an alternate juror may think that they're perfectly suited that they're not going to be disturbed or distracted by media, and the jurors themselves wouldn't know, just like the parties in the court, without that kind of exposure. So because that can be a factor that affects many of us, I think a lot of us, maybe camera shy, for lack of a better word, or just prone to distraction when there's lots of things that are going on, or the pressures of the case when you know that you're deciding a case on something so high profile. I don't think alternates alone would be enough to remedy the problem without having the potential jurors present to evaluate the circumstances and their reaction.
So in terms of both parties' interests in selecting jurors who won't be distracted, is there any case law that's sort of analogous to this situation?
I don't
about kind of that right to have jurors that are paying attention.
Yeah, I think that this extends a little further than just paying attention. I think it's the core concern is that each juror needs to make an honest and independent assessment of the facts before it, and that media pressures can not only create a distraction, it can even subtly influence the way that people view the action that they're taking when they realize it's going to be subject to intense scrutiny. So I don't know that there's independently some sort of right to an undistracted jury, but there is a right to a fair, biased, and impartial jury, and to a jury selection and voir dire process that helps ensure that such a jury is seated. And the presiding judge's interpretation and application of the standing order interferes with that right in this instance.
What case law talks about that? Is there any case law talking about that in the jury selection process
About distraction in particular, or? Sorry.
about, in the sense that there's a legal right to some type of jury selection, or in this case, in person versus online versus virtual, a right to something in the jury selection stage that's connected to the parties' need to make sure that people are able to, that jurors would be able to sit with this type of
I think
potential
that,
distraction.
yeah, I think that, we in our, let's see if I can find, in our reply brief, we talk about how voir dire questioning, this is State v. Saunders, voir dire questioning is essential to in choosing an impartial jury, and an impartial jury is as essential to a fair trial as is an impartial judge. And so I think that the voir dire process has long been recognized by precedent as really being crucial and vital in ascertaining whether we can sit a fair and unbiased jury, whether jurors can perform their duties and apply the law under the circumstances. And I think the key thing here is that it's the trial judge, the assigned trial judge, that bears the responsibility of ensuring a fair and impartial jury can be seated through the proceedings. So the rules grant the trial judge discretion to manage his cases. He's the one in the advantaged position to make a case-specific determination about what means are most appropriate in this case. And the presiding judge's interpretation is allowing her to second-guess that. The case-specific determination is outside of her purview under the rules or the Code of Judicial Administration.
Can I ask a kind of a related question, but coming from a slightly different angle? One of the things that's been kind of puzzling me in this case is whether or not parties have the right to challenge administrative decisions. And so, we have a Code of Judicial Administration. It provides for a lot of things. And I'm just wondering, do parties have a right to come to court and argue that the court didn't comply with those administrative rules?
Well, I have two responses to that. The first is this isn't just an administrative ruling. It's an order entered in this case. It's a judicial order.
And I think that complicates things in this case. And so maybe, I'm not exactly sure why the presiding judge entered an order in the case. It strikes me as a little bit unusual, but let's just assume, for purpose of my question, that she hadn't done that. That someone had just made an administrative decision to say, no, you can't do this in person. It's under my prerogative to decide that under our rules, under our standing order, or under our administrative rules. And I am going to make that decision as an administrative matter. I'm just wondering if you think parties have standing or the right to come to court and argue that those administrative rules weren't followed appropriately.
Yes, Your Honor. I believe this court has addressed that question in the 2000 High County case that's cited in our brief. In that case, the question came about as to whether a case had been properly assigned to another judge. And the argument was made, including by the dissent from this court, that this was essentially an administrative act of the presiding judge, which was not an appealable order.
Right, and the court in that case was looking specifically at jurisdiction. I'm thinking more about standing. I don't think parties have a right, for example, to in-person jury voir dire. Do you agree with that?
I think parties have a right to a jury selection process that helps them seat a fair and impartial jury, and
Okay.
that could involve in-person proceedings.
And do you think that's a constitutional right? Do you think the state has that right?
Both parties, I believe, have the right to a fair and impartial jury.
Where does that right derive from?
The Sixth Amendment.
Even for the state?
I'm not sure. I know the state at least has an interest. I'm not sure if they have a constitutional right like the defendant does, but they at least have a very strong interest in ensuring a fair and impartial jury. And I think the state will take a few moments and perhaps can address that.
And I guess maybe that's my question. If you were here arguing the violation of a constitutional right or some statutory right or some right that arose out of procedural rules, but it seems like you're arguing that a right was violated or that you have a right to challenge an administrative decision, but I'm trying to figure out where that derives from. What gives you the right to challenge an administrative decision?
So first of all, again, this was not an administrative decision. It was an order entered the case, and it's appealable under the statute, under the Utah Code. And second, in High County, this court recognized that this court has constitutional authority to manage the appellate process as well as inherent supervisory authority over all courts of the state. So whether jurisdictional or a standing issue, I think this court has recognized that when there's administrative order at issue from a lower court, it falls under this court's inherent supervisory authority to review that.
And that all parties have standing to challenge any kind of administrative decision?
Well, I don't think parties do have standing to challenge any kind of administrative decision. I think they have standing to challenge an order entered in this case that affects their ability to seat a fair and impartial jury, which is at least a constitutional right for the defendant and certainly a strong interest for the state. So it directly affects the interests of the party in this litigation that the presiding judge made a case-specific order entered in this case that in-person voir dire couldn't be held. So I'm not saying that they could challenge the third district standing order in isolation. I don't know whether that's the case. I know the rules provide for a judge, an individual judge, to refer to the judicial council concerns they have about rules and policies. I don't know what standing the parties would have in that instance, but that's not this case. This case is a case where the presiding judge elected to enter an order making a case-specific determination that in-person voir dire would not be allowed in State v. Richins.
Okay, let me just ask one more question then. So if the presiding judge in this, let's imagine in this case, the trial court judge had just gone to the presiding judge and said, I need your approval to conduct in-person voir dire under your standing order. And the judge said in a letter, I don't approve it. Would the parties have had the right to challenge that?
I'm not sure if that's the case, especially because, let's say it didn't come by letter. Let's say it was just word of mouth.
Sure.
The judge popped over. I mean, there might not even be a docket entry or anything
Right.
that would be necessarily appealable. In the High Country case, there was at least a docket entry, and this court, the dissent disagreed on that point, but
Right.
the majority said that was enough to at least be appealable. And here, there's an actual order. So to your point, it may be a different circumstance if this was just sort of a behind-the-scenes discussion between the presiding judge and the trial judge. I don't know the answer to that.
Okay.
But I do know that where the order has been entered in this case by the presiding judge, it is appealable, and the parties have standing because it affects their substantial rights to a fair and impartial jury and a fair trial.
Okay, thank you.
For the sake of argument, let's just imagine that this court reads the standing order differently than you do, right? And it doesn't set up a process by which the presiding judge is reviewing findings of the district court, but is making the decision on its own in the first instance. What standard of review would we apply to that determination?
This court has applied an abuse of discretion to the presiding judge's case assignment responsibilities, so I think that it would at least be an abuse of discretion standard. However, the challenge and difficulty here is that nothing in the Code of Judicial Administration or court rules empowers the presiding judge to make a case-specific determination in a case she's not assigned to, so the trial judge is the one that all our case law says is in the advantaged position.
Right, and I ask you to assume that
Yeah.
we didn't read the order the way you did, right?
Oh,
And that this
that's-
decision belongs to the presiding judge. And so given what we've said about what it takes for a district court to abuse its discretion, that it's beyond the bounds of reasonableness, how is this decision beyond the bounds of reasonableness?
The decision's beyond the bounds of reasonableness because it was based primarily on broad logistical policy concerns about the benefits of voir dire and the efficiency to the jury, but it didn't grapple with the case-specific facts here. The level and degree of media publicity, the fact that both parties and the court, the trial judge assigned to the case, agreed that in-person proceedings were necessary to enable a fair and impartial jury to be seated, and the fact that we're dealing with a first-degree aggravated homicide case that has such high stakes. The presiding judge didn't take into account those specific facts, and she didn't grapple with the trial judge's reasoning of why in-person voir dire was appropriate under these circumstances. So even if we assume the presiding judge is entitled to make the determination in the first instance, or even if we say she doesn't have any obligation to defer to the trial court, I disagree with both those points, but if we say that's true, she still abused her discretion by ruling outside the bounds of reasonability by permitting in-person voir dire under these circumstances.
Is it unreasonable for her to conclude that those concerns could be addressed with questioning of the jurors?
Yes, Your Honor, because it didn't address the trial judge's reasoning, but even assuming she didn't need to address the trial judge's reasoning, it fails to grapple with the realities here, which is that questionnaires don't assess how parties may react under the circumstances. So as I commented to Justice Peterson a moment ago, the parties themselves may think, oh, I'm not going to be influenced by media. I really haven't heard that much about it, but being present in the courtroom and subject to those media pressures allows the jurors to better understand the pressures that they're going to be under a month-long trial, a 4-week trial, that they're going to be dealing with this type of crowding and media presence, and then the parties in the court to assess the reaction of the jurors and to assess their ability to, tune out these factors and be fair and impartial.
How are you going to assess that? I mean, we keep talking about this idea that once the jurors are exposed to it, that the parties will somehow be able to assess how they react. How do you envision that happening?
Well, I think that below in the transcript of this case, the state made the good point that they wanted to be able to review, to see firsthand the reaction to the media. So this is page 80 of Addenda E. The first is the state will want to measure somebody's reaction to the media, and the state has to be in, the potential juror has to be in the presence of the media coverage for us to measure that reaction.
So are we talking about just looking at them to see if they seem nervous? Are we talking about particular questions being posed? I'm having a hard time understanding what one can get out of in-person voir dire in the presence of the media and the crowding that can you answer that? Sorry.
Yes, Your Honor. Observing the reaction is vital. That's one reason that we defer to the trial judge for credibility determinations when they've been present for testimony. And we say that the cold record is no substitute for having observed a witness testify in person. So being able to observe the jurors' reactions to media presence is important, as the state pointed out below. They want to be able to see how jurors react to the media presence and, whether that reaction, if they, are their reactions showing nervousness or distraction or something that would interfere with their ability to be fair and unbiased, that's something that, might be the basis for a challenge or might be the basis for further inquiry. But if it's the jurors are home in their kitchens, as the trial transcript said for voir dire proceedings, they're not going to be exposed to those factors. And just asking dryly, would you be able to be fair and impartial if there's media, is not enough to assess how the jurors would actually perform and actually respond to those type of pressures.
So you think so it's that question, and you think they might respond differently if they were present in the courtroom?
They may respond differently, but also the parties would better be able to assess if they're being truthful and honest and forthcoming in their response. Because even a juror might assume from their kitchen that they wouldn't be distracted by these proceedings. But if they're there and they're, being, nervous and feeling harassed by the presence of so much publicity in the courtroom or anything like that, it's not only likely the juror will be better able to assess his or her own reactions, but the court and the state and the Ms. Richins can observe the juror's response to those factors and to those questions and make a better assessment, just like the trial judge can make a better assessment of a testifying witness than this court can.
I have one other question. I've heard you refer several times to this constitutional right to a fair and impartial jury. But I didn't understand that was your argument here. I mean, correct me if I'm wrong, but I believe you're challenging whether the presiding judge abused her discretion in deciding that there would be no in-person voir dire here. You're not arguing that the denial of in-person voir dire violates your client's constitutional rights to a fair and impartial jury. Is that correct?
That's correct. Yes, that's correct, Your Honor. The point about the fair and impartial jury has to do with what's at stake here and why it's important that the determination is made in an individualized basis in a particular case by the judge who's best suited and best responsible for the determination of what process will render a fair and impartial jury under the circumstances. But there's not an independent constitutional challenge before this court.
How long do you think jury selection will take? And I know this is a guess, but what's your estimate?
The court currently has 4 days set aside for jury selection in April. My understanding is that the court's planning on sending out jury questionnaires to about 1,500 individuals by the end of this month. I think there's a meeting in about a week to finalize that jury questionnaire. And then the trial itself will take place in April and last about 4 weeks. So the anticipation is that it will be at least 4 days of voir dire.
I have a question about drawing from the two counties,
Yeah.
unless anyone is still. So it seems pretty clear that the Constitution would allow you to draw from two counties within a district. And I'm only speaking from myself, not my colleagues. But seems like it's certainly constitutional to do that. My only concern about it is 78B1 1072, which seems like it's trying to limit it only to the county in which the trial will be held. So in 1072, prospective jurors shall be randomly selected from the county in which the trial will be held. And I think the statutory interpretation argument that the single and the plural are interchangeable works for the other statutory sections that are at issue here or that seem relevant, but it doesn't work as well in this 1072. And so I'm just not sure, after the case in which this court said, yes, it's fine if you draw the jurors from Box Elder County and have the trial up at Cache County. This came after that. It was a couple, 2.5, 3 years later. But was this meant to cut off that option?
So, Your Honor, I think that you're correct that the ruling in that other case doesn't resolve the question of whether it's statutorily mandated. But even assuming this is establishing a mandatory rule, which I don't think it necessarily is, but just assuming that it is, this court has held that that waiver and estoppel can be found in the face of a mandatory statute. So here, even if this is a mandatory requirement, this court has routinely held that parties can waive mandatory requirements, constitutional requirements, and here both parties stipulated to drawing the veneer from Salt Lake County as well as Summit County. So even if it's viewed as a mandatory statute, I think that this court's precedent establishes that the parties can waive that, and their stipulation here did effectively waive any statutory requirement.
In any of those cases, were parties waiving something that didn't constitute a right? Because when I looked at those cases, it seemed like people were waiving constitutional rights, statutory rights, maybe even a right created by rule. But here, I don't know that I really read this as being a right of your party or a right of the defendant or a right of the state. It seems more like it might protect jurors, or it's just an administrative kind of articulation of how juries should be selected, but I don't necessarily read it as creating rights. And so I'm just wondering if any of those cases dealt with situations similar to this where we weren't talking about someone's rights.
Well, the Wolf Mountain case was specifically dealing with an arbitration provision, but it talks about statutes of limitation.
But it does talk about the right, but those are even rights, right? You have a right not to be sued for something that's extended past a certain time.
Yeah, I think that may be the case, that those deal with rights. I think here, we're assuming, even if this court views this as a mandatory statute, that the parties can waive the requirements. But taking a step back, if we look at that Wolf Mountain case, I think it's unlikely here that this actually is a mandatory statute rather than a procedural statute. So in Wolf Mountain, this court said, provisions are generally not considered mandatory, which are not of the essence of the thing to be done, but which are given to a view merely to the proper, orderly, and prompt conduct of business. And by the failure to obey, no prejudice will occur to those whose rights are protected by the statute. And similarly, it says a procedural statute provides a remedy for already existing rights or merely adds to or provides a substitute for already existing remedies. So here the right to jury trial is established constitutionally, including through the Utah Constitution, that defendants entitled to be tried by jurors from the county or district. And this, under the reading of Wolf Mountain, appears to just be a procedural statute that has to do with the general process for selecting jurors. And so I think that under Wolf Mountain, it likely is not mandatory. I think it's a procedural statute, but even assuming it is, it does have the language "shall," perhaps it's mandatory. I don't think that the statute embodies any clear declaration that it's attempting to give jurors rights. I think that instead it appears to be a way to describe or set forth the procedure for selecting a jury when the defendant has the right to jury trial. So I don't see in the language there anything that says a juror is entitled not to serve if they're not in the county. And I think reading this provision as waivable, whether because it's permissive or because it's mandatory and waivable, is consistent with this court's Rule 29C, which allows a juror to be drawn from another county. And so if this rule was read to prohibit that completely, then there would potentially be a conflict between the statutory provision and Rule 29C.
Although 29C seems to be about when you can't get an impartial jury in the county where the crime was committed. And here I don't understand the parties to be arguing that you can't get an impartial jury in Summit County. It's just that it might be hard. It might take longer. There's a concern that maybe on the first try you don't find one, and so by broadening the jury pool, you're more likely to get one in the first go. Is that right?
I think, yes, that it would be much more difficult, but also perhaps impossible. Summit County is a much smaller population than Salt Lake County, and even though the publicity has been national, it's been extensive in Summit County itself, where the Ms. Richins and the alleged victim resided. So I do think that there's potential difficulty in being able to seat an entire jury in this case from Summit County alone. Perhaps it's impossible, but certainly it would be difficult to do on the first try.
So it's sort of a venue light argument. You're not saying we can't get an impartial jury here, we need to move the trial, or we need a different jury pool. But you're saying we might not be able to, we're not sure, but because of the small population, it's possible that we could get into jury selection and not be able to get enough impartial jurors from Summit County, but we'd like to try. Is that?
Well, I think to be clear, that the parties agreed that they would draw from Salt Lake County and Summit County for a couple reasons. And one is that the state feels that it has a strong interest in having jurors from the community that was most intimately affected by this alleged crime present to decide the case. However, given the circumstances of the high publicity there, the lower population, that it would be difficult and perhaps even impossible to seat a jury solely from Summit County alone that's fair and unbiased and hasn't been tainted by media exposure.
So help me understand that if we try to read the various statutory schemes together, that the legislative intent that we would see if we read the Juror Act together with the Change of Venue Act is that the legislature says you can impanel us from if you can get a jury in this county, in a particular county, you can do that. If you can't, you need to change venue. Now, why is that not the way to read the statutory schemes together?
Well,
Because I have to be honest, I don't see anything in the statute that suggests that the legislature intended for a jury to be pulled from two different counties.
I'm not sure if there's anything explicitly that provides for that, but I don't think there's anything that prevents parties from waiving that
we
requirement.
may disagree about that, right? I mean,
Yeah.
because to the extent that the Juror and Witness Act evinces a legislative intent, that if we take the 3rd District, for example, right, that somebody at the western edge of Tooele County isn't going to be called to serve in a jury on the eastern edge of Summit County, like I think you can read that into the statute, that's part of why the legislature uses things like the particular county or the county in which the trial is to be held, that they are trying to protect jurors from the burden of extreme travel.
Well, I think there's 2 points to that. One, I'm not sure that that's a fair reading of the statutory scheme as a whole because there are provisions that seem to anticipate jurors crossing county lines. For instance, 78B 119 says that, jurors get certain expenses for travel, and it says regardless of county lines.
Yeah, and we usually, favor the specific over the general. That seems to be, speaking to a more general situation, whereas we have specific references to, right, the particular county and the county in which the trial is to be held. But my question is, if those protections exist for jurors, right, how can somebody other than the juror waive that?
Right. Well, to your question, I don't disagree that the specific governs, but I'm saying I think it's a stretch to read the policy as clearly protecting the jurors when we do have other provisions in there that seem to anticipate traveling across county lines.
Do you have another provision besides the one you just cited?
Not in my notes
Okay.
here.
Can I ask about
But to your,
that provision, though?
What?
I mean, that provision applies to witnesses and jurors alike, right? And so clearly witnesses might be crossing county lines.
Yeah.
And it's also possible a juror might travel across a county line and back into a county because it's the shortest route of travel.
Yeah.
So I don't think I would even read 119 as supportive of your position. I think it's clearly referring to witnesses, which there's no county restriction.
Yeah. I don't know if it's so clearly referring to witnesses, but
I
assuming.
mean, it says right there, jurors and witnesses.
Jurors and witnesses, but it
Right.
doesn't exclude, it doesn't exclude jurors from, the provision about traveling across county lines.
Right, but do you admit a juror might cross a county
I think
line
so.
to just get to a courthouse in the most efficient way possible?
I think that's entirely plausible. And to that point, to your point, Justice Pierce, I think that when we talk about the travel here, the people from Summit County could easily be traveling further from Salt Lake County, given the geographical size of Summit County. So even drawing from Summit County, if you have someone on the outer edge of Summit County, that's going to be a lot farther to travel than from Salt Lake City, for instance. So I don't know that just drawing from the county, again, clearly embodies a policy of preventing travel woes. I don't think jurors have any right to convenience when they're participating in the jury process. And I don't read the statute as clearly embodying such a legislative intent.
Got it. But let's say that we do, right? So
Yeah.
how could you waive that on behalf of the jurors for whose protection it exists?
Well, I think that, I don't know of a statute in the waiver cases that we've looked at that talks about waiving the right of another party. So I'm just not sure if the court reads it that way. But that is, I think, not a fair reading of the provision, just based on the fact that the legislature didn't clarify anything about the hardships or preventing the hardships, or, sorry, what's the word I'm looking for? Make an explicit statutory right to avoid hardships in voir dire service.
Thank you. It looks like those are the questions.
If there are no further questions, I'd leave the state.
Yes.
Okay, thank you.
Ms. Johnson. Ms. Decker.
May it please the court, Marion Decker for the state. The state wishes to emphasize that we are fully on board with Ms. Richins' arguments in this case. The state also has a very strong interest in proceedings that will produce a fair and impartial jury on the first try. But that's not all. The state has a strong interest in trying this aggravated murder case in the community with the closest connection to where these alleged events occurred. And that's why we have worked with Ms. Richins' defense team to identify solutions that best protect these competing interests, which solutions we jointly broached to the trial judge and which the trial judge initially accepted. The parties stipulated to the circumstances found by the trial judge that the media attention here is an extraordinary circumstance that justifies in-person voir dire. And we have waived any requirement that jurors be selected from the county in which the trial will be held. The state agrees with Ms. Richins that the presiding judge clearly abused her discretion in not deferring to the trial judge's finding that the media attention generated, again, in this case, in this aggravated murder case, is an extraordinary circumstance that requires in-person voir dire. And the state also agrees
Can
with
I pause you there for a second?
Yes.
And just ask about that? So let's say that we disagree with the reading of the standing order that says that what the district court, or the presiding judge was doing was reviewing the district court's findings, but rather the standing order gave the decision to the presiding judge in the first instance. Does the state still believe it was an abuse of discretion?
Yes, that's not a decision that can be made in a vacuum. She's down here in Salt Lake. She's not up in Summit County. It's a totally different scenario, as has been observed. This is more of a rural county. And that's not a decision that could be made in a vacuum. You need the boots on the ground, the trial judge, to tell you the circumstances why this merits in-person voir dire. Certainly, it appears from even the presiding judge's observation, most courts prefer virtual, but even the standing order allows that it's not across the board. There has to be some exceptions, and this case constitutes that. And even though the presiding judge says she accepted the findings, by not deferring to them, that was unreasonable. She's not the boots on the ground.
So what if the trial judge here had denied the motion? Would you still be arguing that it was an abuse of discretion?
If Judge Masrick had denied the motion, yes. Parties would be making the argument that given, again, I mean, we have the findings that he made that the media scrutiny here is in extraordinary circumstances, and would be arguing, I guess, whether if he made an opposite finding, that was against the weight of the facts, clearly erroneous, abusive discretion.
I have no doubt that the degree of media attention in this case is extraordinary, but I do have a hard time connecting that to the need for in-person voir dire. Can you address that?
We're all here at the appellate level. These trial litigators are experienced litigators. As recognized in State versus Litherland, jury selection is more art than science. And they are keyed into the cues of how someone sits, their pallor, the way their eyes are blinking or shifting. I mean, these are experienced litigators. And those small definitions, those small things are more observable, more easily, even how they're sitting in their chair is more easily detected in person rather than from a computer screen from the head up. Again, jury selection is more art than science, and in person is going to give you more detail and more information for these experienced litigators to decide, okay, who's really struggling here, who's okay with, and it's not just the media presence in the courtroom, it's the precautions that are going to have to be taken to protect those jurors to even get them in the courtroom. If there has to be busing involved, that is going to also impact the jurors, and those are subtle things that experienced trial litigators are going to be better able to assess when they can see them in person from a few feet away.
And I've never conducted virtual voir dire. That was way after my time. But I have done a trial with intense media scrutiny, and we were always extremely concerned with exposing the jury to that kind of attention. And I think I saw that concern reflected in the presiding judge's order as well, that, it would be better to ensure that the jury's privacy was protected, their safety was ensured, rather than trying to intentionally expose them to a circus-like atmosphere to see what their reaction was. So I'm just a little confused about how you're going to expose the jury to that, and then what information you're going to gain from that.
And again, let's step back. The standing order doesn't have any criteria. We weren't required to explain how we were going to get the jury to the courtroom. And we have rules and constitutional protections for jurors. That's a given. Once we get the ruling that we can proceed that way, then of course we're going to protect the jurors. And it's those precautionary circumstances. Again, they may have to park in a remote location and be bused to the courthouse, and that is going to impact the jurors. It's all of the whole ball of wax, getting there and then realizing you're in this case that you may have heard about, and whether you're going to be able to withstand a month-long trial under these kinds of conditions. These experienced litigators need to be able to assess the impact of all of that on the jurors as they're having that in-person dialogue.
So after the jurors have had this experience, whatever that exactly looks like, then the litigators feel like they can ask the question, can you be distracted? Can you put this aside? Do you feel intimidated? And that they're going to get a more informed response from the jury. Is that the idea?
That's certainly part of the idea, but it's not just that question. It's all of the questions being asked and how the jurors are holding up and how they're behaving during the whole thing. They're not just reliant on the questions, it's the whole atmosphere and reactions. A juror may react to something over here. It's the whole ball of wax that they can see better in person for in-person voir dire rather than just limited to one face at a time, the Brady Bunch on virtual voir dire. That answers the court's question.
It does, thank you.
We also agree with Ms. Richins that given the parties' considered resolution of their competing interests here, the trial judge clearly abused his discretion in reconsidering his order, expanding the veneer to a neighboring county, Salt Lake County. I just wanted to make a few points. As regards the Administrative Rule 4-404C6C3, the date, time, and place language of that rule, necessarily, no one else but the trial judge can determine the date and time for jury selection. It only stands to reason the trial judge would also decide the place, and here that would be in person or virtual. As far as whether voir dire and jury selection are purely administrative rather than judicial functions, there would have been no need for this court to amend Criminal Rule 18 to require virtual jury selection during the pandemic, or to remove that provision in Rule 18 after it issued its August 6, 2022 administrative order ending mandatory virtual proceedings if it had been a purely administrative function. The court's doing so shows that these are more than administrative functions. They are judicial functions.
Can I ask one more question on the jury selection? So you were saying that, is it 1,500 that would be summoned for this case?
Apparently.
So would all of the 1,500 people go to the Summit County Courthouse?
I think the anticipation is that the jury questionnaires are going to weed out a large number. Again, I'm not a litigator, so I'm not experienced on how much that's going to reduce it, but I do expect that that's going to be reduced quite a bit by the jury questionnaires themselves, and then they'll have them come in, as I understand, in batches and over 4 days, so they're not all going to descend on the court at one time. And then, because time is of the essence, we would suggest that the court perhaps consider treating this as an election law case and submitting a ruling with a decision to come later.
To that end, when would you need that ruling?
As soon as you could get it to us. I mean, the questionnaires are going out on presumably the 21st of this month. Is that right?
At the end of February.
End of February?
So how much in advance to the end of February realistically? I mean, I understand they need to get out as soon as possible, but sometimes it's easier for us to work from the far end. At what point have we interrupted proceedings if we wait too long to get a ruling out?
Well, certainly, if we want to go to both counties before that date, before the questionnaires go out, we would need a ruling from the court. So that the district court knows to which 1,500 jurors he's sending the questionnaire.
And do you have a sense of when that needs to be decided by?
Well, again, the questionnaires are going out end of February, so.
And do we know how much in advance of the end of February administratively we need to?
I can address that.
Okay,
Okay,
we'll get you a reply.
I'll let my
Okay,
capable
thank you.
counsel handle that. The state has nothing further to add if there are no more questions.
I have one on the 2 counties. So this seems to me like a great solution, reasonable request. The Constitution, just from my reading to this point, and don't hold me to this if this were really at issue in some case, but the Constitution seems to allow it. My only question is whether these statutes prohibit you from doing it. And so I'd like to just hear your best argument that says, no, even though this statute seems to assume that jurors will be drawn from the county in which the trial is being held, that nothing prohibits us from thinking outside of the box and drawing from 2 counties within the same judicial district. What's your best argument on that?
Well, I think, again, where the county, where we have competing interests here, and we've come together with a solution that we waived those statutory requirements, and this isn't outside the bounds of what we've asked of jurors in the past, and it's been upheld. Where the parties are agreeing that this is a process that will make both of them feel comfortable that their important interests are being protected, that yes, and just because it's not a specific defendant's right, all the more reason that we should be able to waive and this court not have to delve into whether or not it's prohibited here, because the parties have agreed to excuse those protections in this case to advance these important interests in proceedings that will ultimately produce a fair and impartial jury. We're all very interested in that. If there isn't a fair and impartial jury, then we lose the integrity of our conviction. And we have the added interest of holding the trial in the community with the closest connection to these events.
So our criminal rules contemplate drawing from a different jury pool, even if you stay in the county.
Right.
But the state wants to also draw jurors from Summit County.
Yes.
And is that part of the interest in having it in the place where it happened, that it's not just that you want to hold it in Summit County, you also want to be able to draw jurors from there?
Yes.
Okay.
Yes.
But the extent to which that these statutory protections exist for the benefit of jurors, can the state waive those on behalf of potential jurors?
Well, again, all of these rules and procedures are in place for the ultimate goal of affording a fair and impartial jury. And there's nothing that jurors are being asked of here that's ever been found outside the bounds.
So let me ask it again, right? Let's say that we read the statute and think, all these references to particular county, this county, that seem to indicate that a jury pool will be selected from a single county, evince a legislative intent that jurors not not be called to travel from, one part of the district to another, even though perhaps constitutionally they could have done it, right? Let's say that is something that we find in the statute. Can the parties waive that on behalf of jurors?
I think we can, where the defendant's interest is the one that's the most important here. The defendant has a constitutional right to a fair and impartial jury, and that's what all of this is about. The state has an equal interest in that, seeing that constitutional right is served, and the statutory right of a juror to serve in his own county, I think, falls by the wayside when the parties agree to do that.
But if we read the statutory schemes together, what would prevent us from saying, well, it seems like the way the legislature has dealt with that is through change of venue? That if you can't get a fair and impartial jury under the rules we've set up, you can ask for a change of venue. Why is that not the
Well,
better way to
again,
read the statutes?
there's more interest here at stake, and Summit County has an interest in having this trial held and with jurors from the county in which the crime occurred. And so the parties have come to this compromise where we'll take jurors from two different counties, one where the aggravated murder occurred and one from a neighboring county in the same district. And they're comfortable with that and feel like everyone's rights are protected. So that's what should happen here. And it was abuse of discretion to ignore the parties' considered joint resolution that protects both of these important interests.
I just wanted to add one comment. Obviously, we're going to have to decide whether the compromise that the parties came to is permissible under the statutes, and if not, whether the parties can waive it. Those are legal issues we have to consider. But I just wanted to commend the parties on working together to find a solution that protected both of the parties' interests and also protected the important constitutional rights of the defendants. So thank you. It's encouraging to see the parties working together on these issues.
Thank you. It has been a delight to work with my colleagues on the defense bar. Thank you.
Thank you. Mr. King.
Mr. Chief Justice, and may it please the court, good morning, and on behalf of Presiding Judge Scott, thank you for the invitation to join the court for arguments today. I'm looking forward to our discussion. This court should decline to exercise its discretionary jurisdiction in this case for two reasons. The current practice of virtual jury selection in the 3rd District Court and the substantial framework that supports that practice cannot survive a ruling from this court that each individual judge within the district has discretion to determine whether to hold jury selection in person or virtually, or a ruling from this court that the parties may jointly stipulate as to whether to hold jury selection one way or the other. Either ruling would invite the contemplated nightmarish consequences this 3rd District bench envisioned when it agreed to and adopted the policies that led to the standing order in this case. Second, and as Justice Peterson rightly acknowledged, neither party has challenged the legality of the standing order. Neither party has raised a claim that the standing order itself or Judge Scott's denial of an exception to the standing order in this case infringes a statutory or constitutional right. The parties have a preference about how they would like to conduct jury proceedings and jury selection in this case, and they reach a conclusory opinion about why their position is supported. But a preference and an unsupported legal conclusion doesn't warrant this court's continued attention. In the event that this court were to invoke its discretionary jurisdiction, nonetheless, it should affirm Judge Scott's decision because, one, she rightly exercised her authority and did not abuse her discretion when she made the determination that the parties lacked extraordinary circumstances for an exception to the standing order.
Can I stop you there? Under the language of the standing order, was that, and this goes to something that Justice Hagan was asking earlier, is that a required finding that the presiding judge had to make?
Of extraordinary
circumstances? I mean, certainly that's the way that her order is written, not the standing order, but the order that's being challenged is written. But was that a necessary finding?
Extraordinary circumstances is a prerequisite to receiving permission for an exception to the standing order.
So if that's the case, why isn't the trial court judge in an advantaged position to make that determination?
I think what that question goes to, Justice Pierce, is a question about what the correct standard of review here is. But we're not conceding that Judge Scott was in appellate type review. We maintain the position that Judge Scott was not in appellate type review. But I will assume for the sake of your argument, Justice Pierce, that this court believes it was appellate type review and that a standard should apply. Is that fair?
That's fair, and I may chime in with another question when you're done.
Please. And if that's the case, then the parties have not articulated the correct standard of review. In fact, in their reply brief, they argue that this is a mixed fact or fact-like mixed question of law, but it's not. It's a law-like question. And we get there because of this court's three-prong test. And the appellants have omitted the third prong. The first prong is whether the trial court findings or the findings themselves are varied and complex. The second part, which we would concede, is that the trial court is in a position to rely on those findings when issuing a ruling. And the third part, omitted by the appellants in their reply brief, is the policy considerations that weigh for or against deference towards the trial court findings. That first and third prong favor a law-like question standard here in this case, where Presiding Judge Scott was not required to defer to the trial court's finding about extraordinary circumstances. So even if we argue that the trial court itself is not in a position to determine those, it's outside of the point. The presiding judge, via the standing order and her administrative responsibilities, is entitled to make that exception or make that determination about the exception herself and give authority for an exception to the standing order.
So, be that as it may, if we go with the AOC's position that the presiding judge isn't exercising appellate-like review, right? So, and I believe that the AOC's position is that the presiding judge is making this determination of extraordinary circumstances in the first instance. Is that correct?
May I clarify that,
Please,
Justice
yeah.
Pierce? It actually goes to the scope of my representation, which is not for the AOC. So I cannot claim that I represent the position of the AOC.
Oh, that's fair enough. Yeah.
I can only claim that I'm representing Presiding Judge Scott in the 3rd District Court.
Okay. So the position that's articulated in the brief, if I understand it correctly, is that this is not appellate-like review. That Judge Scott, sitting as presiding judge, made the determination of extraordinary circumstances in the first instance.
That's correct.
Is that correct?
That's correct.
Okay. And so if there's an issue with respect to Judge Scott not being in the best position to make that decision, that's a flaw in the standing order and not something that should cause this court to set the decision aside. Is that your position?
I don't think that that's informed by the controlling authority on that case, in that situation that you're articulating, because if this is not if this is not appellate type review, but it is an administrative review of a trial court's findings with regard to the scope of the standing order, we don't have a rule of judicial administration that speaks to what kind of standards would be used by the presiding judge when making administrative decisions like that. And it's because that administration and the administrative duties that she's authorized to control start with her, not with the trial court judge here. Does that fully address your question, Justice Pierce?
I'll reserve on fully, but yeah, no, that speaks to what I was asking.
I think it does highlight, and I think this entire court is correct, it highlights the unique nature of this case, because there seems to be, at a minimum, overlap between what is an administrative decision and what is a procedural or judicial decision. And in that case, we have reached a gray area where this court hasn't articulated or weighed into how do we come to determinations like the one that the presiding judge made in this case, and should we interfere with the presiding judge's authority to make those determinations in any way?
Or decide whether or not the presiding judge has the authority in the first instance, which I guess is not an argument that's currently before us.
Exactly, yes. That was my second point in the opening, was that we haven't challenged or attacked the constitutionality or the legality of the presiding judge's standing order in the first place. And that's not to say that there isn't a remedy available to that, and counsel has acknowledged that. If the trial judge disagrees with the presiding judge's decision, the trial judge can go to the counsel. And that still remains available to the trial judge in this case. And yet he hasn't explored that. I don't know what that means, but that remedy being available to him seems to be the relief available should the trial court judge disagree with the presiding judge in this case.
Can I ask you a question about drawing the distinction between whether this is administrative or judicial? I think it's confusing, right? I mean, and we've talked a little bit about where the lines start to blur. In this particular case, it seems like the presiding judge was expecting arguments from the parties. You know, she said, the parties haven't persuaded me. And then she issued an order in the case. And that very much feels to me like a judicial type of operation as opposed to an administrative type of operation where someone might have come to her and said, we'd like to use this courtroom. And she says yes or no. So I'm just trying to understand what standard do we use to draw the line between whether this is an administrative action by her or whether it's a judicial action by her?
That's a good question, Justice Pullman. And I think there's a couple things to unpack. First, what it seems to be you're asking is what is the standard to apply to determine whether a decision by a presiding judge in a situation like this is administrative or judicial. Is that a fair?
Yes.
And then the other question I think that you're asking, and I have followed it in the questioning with appellants as well, is at what point did this perhaps cross the line from an administrative decision to a judicial one? And I don't concede that entering in the docket a decision about granting or denying a request to the standing order crosses that threshold. I'm not sure if the court is contemplating that hypothetical that as soon as a docket entry is made, that's when it crosses from administrative to judicial. I see that and I read Judge Scott's actions in that situation as at least informing the parties formally that an administrative decision has been made, and I would stand by that. And that does not cross that threshold. Does that fully address one of the questions I think you're
Let me
raising?
just ask for a follow-up to that, and maybe
Please.
it will get into the second question, but I could see, I mean, I don't think we should draw the distinction necessarily on just whether something gets put in the docket. I mean, that seems too arbitrary to me. But where she seemed to be addressing arguments in the same way the trial judge would have, and seemed to be expecting persuasion from the parties, that to me is maybe the substance of it felt very judicial as opposed to worrying about whether it shows up in the docket or not.
So if I understand Justice Pullman, what you're saying is that the anticipation of pushback from the parties or the anticipation that they will have articulated some kind of persuasive argument.
It might just be the way she analyzed it, right? It felt like she was assuming a trial court role in a way that seemed different to me than maybe what I would ordinarily expect from an administrative type decision.
Mm-hmm.
And so I'm just trying to figure out here, what's the proper bucket to put what she did in?
I see. I don't know that it should actually be so surprising the manner that she analyzed the party's request, because we are all, after all, judges. We all think legally and logically this way. And so I think that the way that the decision was made follows the logic of this is the way that things are. So I see that as being, that's normal for a court and business as usual, so to speak. As to your second question, and this is a really difficult question to reach because I don't know that the court actually is in the best position to articulate a standard about when does a presiding judge's administrative decisions cross the threshold to becoming a judicial proceeding. I don't know. This court has never addressed that issue. This would be the first instance that it has. But it does highlight the competing interests between two bodies of government that exist in the judiciary, the Supreme Court and the Judicial Council. And I'm not aware of whether or not this court has conferred with the council on that matter or whether the council would have an opinion on that matter. And as I explained to Justice Pierce earlier, I cannot represent the council's position or the AOC's position on that regard. Unfortunately, I don't know that I have a great answer for you, Justice Pullman. I think that that could be an answer that warrants additional briefing if we had additional time. My argument is that there are valid policy reasons that invite this court to decline to exercise its discretionary jurisdiction on that specific issue. This would not be the case to find a solution to the question that you're proposing.
Okay.
I
Thank
have a follow-up to that, but I don't want to.
No, go ahead.
Okay. So the question about whether this is administrative or a judicial legal decision, I think is interesting because we're interpreting the standing order, we're looking at the standing order, and we're analyzing extraordinary circumstances. And the suggested definitions are from case law, but it seems like from the presiding judge's perspective, what she would be looking at administratively is this so unusual? So if we've got we now have a framework for virtual jury selection, and the requests for in-person, I'm assuming, and I appreciated your description of how it works logistically, and I still don't completely understand everything that it must take to do that. But if it seems like from the presiding judge's perspective, if we say that this is an extraordinary circumstance, we have too many cases that are like this, and that is going to gum up the works. It's more of a logistical administrative consideration than a legal consideration about what threshold do you need to meet before saying, hey, we're not going to be able to pick a fair jury, right? So the legal question of, in this particular case, do we think that unless we do it in person, we can't pick a fair and impartial jury, and this is a legal question, and at what level would that happen, is different than the presiding judge's consideration of where do we draw the line at extraordinary, and any case that's above that line could ask for an in-person jury selection, and if that's too many, that's going to make it administratively difficult for us to continue this program of virtual jury selection.
That seems.
You see what I? Yeah.
I didn't mean to
that make
interrupt
sense?
Yes, it does, Justice Peterson. It seems to be you're highlighting one of many concerns. Probably the top priority. It's as I articulated in the beginning, the fallout consequences of a ruling from this court that her decision was of an abuse of discretion, that the bar might be too high, that these do warrant extraordinary circumstances. The top priority in terms of identifying the fallout is that the current framework that the Third District has implemented, the bench specifically has implemented, is untenable at that point. It cannot operate that way. But as it applies to this case, I think Judge Scott rightly addressed some of the other issues that are grave concerns with the party's proposal. There are massive court security concerns that stem from bringing 1,500 people in a 4-day period through a very small courthouse that you're aware of. There are significant privacy concerns. There is nothing that's been articulated and nothing that I'm aware of that could prevent things like jurors being photographed or even jurors being interviewed. Everyone at the courthouse for those 4 days will know why people are there that day.
And it seems like there are two things in your response, and in the presiding judge's order. So one thing that would be a logistical problem is if district court, the trial court, makes the decision in the first instance and the presiding judge is just reviewing it. That would be a logistical problem for the overall virtual jury selection framework, because you'd have 32 different judges making the first cut at the decision, and then the presiding judge doing it in an appellate-like review. So it would lack consistency.
We can hope for uniformity among the bench, but in a real world, we're going to get dozens of opinions about what does constitute extraordinary circumstances, right, and who's in the proper administrative role to make that determination.
I'm just wondering, in a case where the presiding judge said, yes, these are extraordinary circumstances, I give an exception here, what would be different? What would that look like for the jury clerks and the people to implement in-person voir dire in a particular case?
I actually think that point is important, Justice Peterson, because we have never contended that in-person selection can't be accomplished in the Third District Court. We can concede that in-person selection can absolutely be accomplished. And even in this case, Judge Scott has never taken the position that that can't be done. What she has done within her administrative responsibilities is reviewed a request to the exception of the standing order saying, this is not a case where we should be doing that.
I think it's interesting you say that, because one of the questions I had about the standing order is whether or not, if it's extraordinary, then you're entitled to in-person, right? Or is it that it might be extraordinary, but there still might be reasons not to give you in-person? That was not a very good question, but I'm just trying to see if you agree that the latter is the proper interpretation as opposed to the former. Because it almost seems like the argument from the other side is this is extraordinary, and once we've shown that, then we're entitled to in-person voir dire. And I'm not sure I read the standing order the same way, and it seems like from what you're saying there that, sure, this case is extraordinary or could be extraordinary, but not sufficient to warrant the exception.
I understand what you're saying. There could be circumstances that do constitute an extraordinary circumstance, and yet the prior approval prong of the standing order's two-prong test is what you're saying. Maybe there are additional unspoken or unwritten criteria that
Or
would
even just the
inform-
concerns they identify or other concerns that might arise in a particular case. I guess I was just trying to figure out, I mean, it's hard for me to say that this isn't an extraordinary case. It's not ordinary, right? So, I mean, we see lots of just garden variety cases, there's no media attention. And I'm not saying every case that receives media attention is extraordinary, but this one to me does seem to rise. It's not ordinary, let's put it like that. And so I guess my question is, does that mean under the standing order that the in-person voir dire should have been granted? Or does it just allow the court to then make an additional, or the presiding judge, excuse me, to make an additional determination as to whether or not, given those circumstances that may be extraordinary, we should still proceed with in-person or online voir dire?
I think I track your question, Justice Pullman, and if I don't, please correct me. I think the question puts me in a very difficult position to concede the argument here that this isn't an extraordinary circumstance, and I don't concede that. I actually don't think that this case it is extraordinary. It's not ordinary, but it doesn't rise to the level of extraordinary. It falls somewhere in between that. In the brief, we highlight this very point about drawing an illustration between not just this case, but all the other pending cases. I mean, there are 221 other pending homicide cases with high levels of media attention. And there have been recent cases, and I know that the appellants take exception to our reference to the Gwyneth Paltrow case, but that is an exact case that shows that gavel-to-gavel coverage of a trial in Summit County, if I'm not mistaken, still led to the seating of an impartial, fair jury. So if that case, the 221 other cases that are pending, and the dozens that have come through the 3rd District Court since the issuance of this standing order and the predating administrative orders requiring and then encouraging jury selection done virtually can lead to the sitting of an impartial, fair jury, why cannot this case? And that's where I say it falls short of extraordinary circumstances.
So you're judging extraordinary by whether or not online voir dire may not be sufficient to sit an impartial jury. I mean, how are you defining extraordinary, I guess maybe is the right question to ask.
I think in this case, what we're defining extraordinary is based on the factors that the parties believe constitute extraordinary circumstances and the presiding judge's determination about, okay, well, what does this case look like that raises to the level of an extraordinary circumstance? Maybe if I could give you an example of what does constitute an extraordinary circumstance.
That would be helpful, yeah.
Would be a grand jury proceeding. A grand jury proceeding would be entitled to the amount of secrecy that the grand jurors need to have because we cannot control what happens virtually in those proceedings, and the possibility that information, however explicit or general, could be leaked outside of the virtual confines of the jury selection in that situation.
That's a good example, but can you give me another one that doesn't involve a grand jury?
Yeah, I think another example could be, and this would be outside of 3rd District because I don't think we have this problem here, but another example could be that in another district where an internet service provider is the only Wi-Fi provider for that particular community, and it's determined that they're going to use virtual jury selection, but the Wi-Fi is out. That would be an extraordinary circumstance rising to the level justifying an excuse if we assume that that judicial district adopted a similar standard and standing order.
So that would apply to any case regardless of case type. Is there anything based on case type or particular facts of a case that could meet your client's definition of extraordinary circumstances?
No, not that we've discussed and not that I'm aware of.
So no case type would be.
The ones that
Nothing
we.
about the case itself would make it rise to extraordinary. It would need to be kind of like extraordinary circumstances that would make virtual jury selection logistically difficult.
I think what the court's asking is if there's first a case type that would, on its own, justify an exception to the standing order.
Well, I'm sorry if I can clarify my original question. I wasn't talking categorically about case types.
Okay.
I'm just saying that given the two examples you've given, it seems like there's nothing in this case that the state and defendants could have pointed to that would have convinced the presiding judge that this was an extraordinary circumstance.
Mm-hmm.
And I just want to know if that is the way your client reads the standing order.
I don't think that there is anything in this case that they could point to that would justify an extraordinary
So
circumstance.
now let's go to the hypothetical situation. What hypothetically could occur in a case like this that would arise, that isn't technological, right? That involves the facts of this case, that could meet the standard that the third district has promulgated in the standing order?
I don't think that I can be responsive to that question, Justice Pierce, because I don't think that there has been sufficient time since 2023 where the presiding judge in the third district court has been presented with facts in a specific case that constitute an extraordinary circumstance justifying an excuse to the standing order's requirements. And I think that that's rightly so, because the third district bench, when it discussed how to proceed after the end of this court's and the council's administrative orders, it agreed to this standard, and it agreed that this would be the policy of the third district court. I don't think that this court should weigh into the policy considerations that the third district court and the bench discussed when they formally adopted the standing order. So I can't, in that hypothetical, describe situations that could come up in a case because they simply just haven't been presented at this point.
Yeah, but that's kind of the fun of a hypothetical,
I know.
right? Is that we don't have to wait for them to come up. We try to imagine what might happen. And I just want to give you an opportunity to try and come up with something to tell us that it's actually conceivable that a party could meet the standard of the standing order.
I think, Justice Pierce, your question goes to the high bar set by the third district bench. And there are only a couple situations that would warrant making that, exceeding that bar and passing that bar. That's a determination that was made by the third district bench. They've agreed to it. I know that all judges, as we've conceded in our brief, don't agree with the practice of jury selection per se, but the standing order remains valid, and nobody has challenged that standing order in this court or in the council since its promulgation. I apologize that I'm not more prepared to discuss the hypotheticals with you. And
No need to apologize, but it would be helpful to understand well, maybe we do understand based upon your answer that at least, we sitting here today, we can't conceive of something case specific that would allow a party to get in-person jury selection the way your client has interpreted the standing order.
Right, rightly so. And I understand that would aid this court and help this court in determining what does constitute extraordinary circumstances to be able to define what does and what does not.
I need a little clarification on how the presiding judge is interpreting the standing order. As I read it, to be honest, I thought it simply gave discretion to the presiding judge. I did not see it as creating a legal standard. I mean, it didn't say, absent a showing of extraordinary circumstances, the presiding judge either will or may do something. It just didn't read to me that way. It sounds, though, like her interpretation is that extraordinary circumstances is a bar, is something that has to be met to even consider giving prior approval. Is that accurate?
No, and Justice Hagan, I appreciate
Okay.
the opportunity to clarify maybe something that came up from other questioning. That would be the case if I have to concede and I have to argue that we are in appellate type review. that would be a legal standard created, but we've not conceded that. What we've said instead, that this is an administrative review by the presiding judge. So we actually take and adopt the same position that you initially did when you read the standing order, that this is not a legal standard created. But
Okay.
go ahead. Sorry, Justice.
No, that makes sense to me. My next question was, can a presiding judge create a legal standard through a standing order? But if, so your position is that absent extraordinary circumstances, that was not attempting to create a showing that a party had to make, or a finding of, or that either the trial court or the presiding judge had to make. It was just saying that the court had discretion and wouldn't exercise that discretion except in an unusual case. Is that how you read it?
Within the administrative scope that we're discussing, or the context of the presiding judge's administrative duties, I do read that way.
Okay.
I think it's also too important and highlight that the Administrative Management Committee of the 3rd District Court, which Judge Mrazek, the trial court judge in this case, sits on, agreed that that would be the way administratively to seek an exception from the standing order. That Administrative Management Committee and the 3rd District bench is it is a part, inherently in part, of the construction of the standing order as you've read it, Justice Hagan.
Okay.
Can I
It
just
is a
follow up
little-
on that?
Can I just one
Yeah,
more,
please.
and then I'll switch. I mean, it is a little confusing though, because in the ruling, in the order that's being challenged here, the presiding judge refers to the parties having not made that showing, and addresses it as if it is a legal standard. That's why I think there's some confusion. And it almost seems like it's the way the parties have argued it here is are there extraordinary circumstances or are there not extraordinary circumstances? That seems inconsistent with the way I initially read it and the way that you just articulated it. Can you address that?
The best that I can do to address that, Justice Hagan, I believe, is to just point back to the earlier reference or the argument that I made, that if an administrative body like the 3rd District's bench or its Administrative Management Committee in consultation with the presiding judge is going to set a standard for when an exception to the requirement for virtual jury selection meets that standard, they're going to articulate it likely in a way that makes sense legally, because that's the way that judges and our brains and our thought processes work. To the extent that that means, by definition, it is a legal standard, I think is misplaced, because their actions, their conduct, and the resulting standards all stem, we believe, from the Code of Judicial Administration and their authority under that Code of Judicial Administration.
You asked the exact question I had, so I guess just to make sure I understand. So the fact that the presiding judge wrote an order that said, because extraordinary circumstances haven't been shown, the party's request is denied, we shouldn't take that and say, well, this is a judicial decision. It's more of just the way she's normally used to doing things. But I guess I'm just still struggling with this. It seems to expect a showing from the parties. But then it seems like your argument is that's not how this is supposed to work.
It's not.
Okay.
And because we've used language that we would find similar in judicial proceedings, we shouldn't classify this as a judicial act
Okay.
or a procedural act and put it into the vacuum of she's now crossed from her scope and authority as an administrative function to a judicial function.
Okay.
Thank you, Justice Pullman.
What if the trial court had an argument from parties that in their particular case, there was a legal right of the parties at stake if voir dire was not in person?
Mhm.
How would that work? And it's a legal argument from the parties that we need in person here because the defendant's constitutional right to an impartial jury will be violated if, for whatever the circumstances, I won't come up with a hypothetical like Justice Pierce, but let's assume.
I would appreciate it if you did, Justice Peterson.
Let's assume a defendant has made an as-applied argument in their case, in their circumstances, that virtual won't work here for a legal reason. how would we handle that?
Then the question would be, is this court rightly within its jurisdiction to address a preserved legal question? Is that what you're getting at, Justice Peterson?
Well, I guess also, and that seems like a decision that would normally be made by the trial court if it's a legal decision, and I realize that could, I mean, we don't have that before us, and so we don't need to delve too deeply into it, but I'm just wondering if that's a separate situation than what we have here.
It is a separate situation, but I'm happy to entertain that possibility because, as I've argued previously, let's assume for sake of the argument that the trial court judge makes what we construe as a legal finding, and the presiding judge, acting not as an administrator but as a judicial, in her judicial capacity for procedural arguments, the presiding judge makes a legal review or an appellate type review of the trial court's findings and ruling. How should the court treat that?
I am thinking more just at the trial level and presiding judge level, how would that work?
Well, and can I suggest that
Please.
that did actually happen here? There were two challenges brought to the trial judge. One was that it was unconstitutional to conduct voir dire in this way. The other was that the court should, right? And the presiding judge did not review the trial court judge's determination that it wasn't unconstitutional. If the parties had wanted to appeal that, they would have come to the appellate courts. Is that right?
I don't know that I agree, Justice Hagan, and I think I don't agree that the trial court judge himself weighed into and fully discussed the issue of the constitutionality of virtual jury proceedings.
He did. There was a constitutional challenge, and the court said, no, the parties have not given me any authority to suggest that virtual voir dire is unconstitutional, and so I deny that part of the motion.
Mm-hmm.
And the presiding judge certainly did not review that.
Correct.
That would have had to come to an appellate court to review. Is that right?
I agree. And I think if I'm tracking you correctly, Justice Hagan, you're also making the case, which I made earlier, that that's a good reason for this court to decline discretionary jurisdiction in this case, because there's just simply no substantive legal argument before the court that's been preserved by the parties as to the constitutionality or legality of either the standing order or the conduct of the presiding judge.
Well, and that was not the point I was making. The point I was making was that the question that Justice Peterson raised about what if the request for in-person voir dire had been based on assertion of a constitutional right. And I was suggesting that that did happen here, and that that's not before us because of course, the presiding judge appropriately did not weigh in on that. So perhaps the manner in which it happened here is the manner in which it should appropriately be done.
I don't disagree with you, Justice Hagan. Thank you.
Can I ask one other question? I realize we do not have a challenge here to the to the standing order, but I have thought a bit about whether this is administrative or procedural in terms of whether this type of determination should be made in our rules of criminal procedure. And along those lines, I was thinking about that particularly given that this court has adopted that Rule 17C about when proceedings should be conducted virtually and when they should be conducted in person. And that rule, as I believe the appellants have pointed out, does say that the trial judge shall in the first instance decide whether something should be in person or remote, and then the presumption is that they will honor the party's request to appear in a different manner. What does that do to the standing order? The standing order was issued before we issued that rule.
Correct.
Does Rule 17.5 trump the standing order? Now that this court has actually weighed in on that issue of in-person versus virtual through our procedural rules, does that have any impact?
That would only be the case if this court were to find, and we request the court not find and not rule this way, that 17.5 and 18 are the only rules that govern the issues presented before the court today. That simply just cannot be true, because the CJA makes it clear that there are issues that are administrative in nature, even if they overlap with our procedural rules. Those administrative rules and policies inform the conduct of the presiding judge in this case. So I would say no, it does not supersede the standing order. The standing order is a supplementation of that third district bench's policy to enforce 17.5 and how it's constructed in a case-by-case situation.
Okay, so it directs the trial court how to initially schedule the hearing. And then 17.5 would simply allow the parties, for instance, to request to, in this example, appear in person. The parties themselves, not as the rule makes clear, it doesn't necessarily impact any other participant in the proceeding.
Correct. Participant is a defined term in that rule. So certainly, the parties can appear in person, they can appear virtually. One can appear in person, the other virtually, in the hybrid format allowed by the rule. Rule 17.5 and the standing order work cooperatively in the third district as determined by the policy of the bench adopted to inform how jury selection proceeds in that district and in that district alone. The standing order doesn't reach any further than that. It simply ends the information it provides on the court's operations.
It looks like those are the questions. Thank you very much.
Thank you. It's been great to be with you.
Thank you. Ms. Johnson, you have your full rebuttal time.
If I could, I just wanted to go back to a couple
Thank you,
questions
yeah.
that you had, Justice Pierce. The parties have a hearing scheduled on February 21st to address the jury questionnaire before it's sent out, and the trial judge is hoping to have that sent out as soon as February 25th. And since he needs to know what the pool that he'll be sending it to, if this court could render a ruling by February 21st, even if it issues reasoning later on, it would be very helpful for the time-sensitive nature of these proceedings.
Thank you.
And then to Your Honor's second point, or another point that you raised about the jurors' rights, I want to direct this court to 78B110, which talks about limitations on jury service. And in that provision, there are specific rights for jurors that they won't be required to participate in more than one jury proceeding in a certain amount of time, or things like that, that are identified in terms of limitations that create a right for the jurors. And there is not a statement there that you won't be required to cross county lines or serve in a different county. So I think that cuts against Your Honor's discussion about whether 107.2 can be interpreted as creating a right versus a procedural matter. And then finally, I just wanted to go to the amicus's point about whether or not this is a judicial versus administrative ruling. And so the standing order itself is administrative. It's policy, it's district-wide. But when the presiding judge elected to enter an order in this specific case based on a case-specific evaluation, so not a general consideration like electronic impairment is the only exceptional circumstance that exists, or logistical concerns, there's not a courtroom available. This court elected to engage in a judicial order in this specific case that affects the ability of the parties to proceed in the manner they requested for voir dire and jury instruction. So this is a judicial ruling in this case. If it had been behind closed doors, a phone call, something like that, that might be different. That may be administrative, but here it was entered in an order in this case, and it turned on a case-specific evaluation. And then finally, I wanted to note the parties did also file a petition for extraordinary relief if this court were to determine that this was administrative. That was dismissed on the basis that this interlocutory appeal provided a sufficient avenue. But if this court did have concerns, is this an administrative ruling? It's not. But if this court had concerns along those lines, we would ask to reinstate the petition for extraordinary relief, and that is cited on the same grounds here.
Can you address the statute 107.2? I think that the language that seems like the legislature wants the jury to be drawn from the county in which the trial is being held. And I think when you were talking in your initial argument about whether that's mandatory or not, maybe this is what you were getting at. That I guess what I'm wondering is, that statute says the jury should be drawn from the county in which the trial is being held, but does it have to be, whether it's a waiver issue or not, I'm not sure if I'm conceiving of it as waiver, possibly, but would it be a violation of the does it say you have to do it that way? That it can only be done that way, or that's just the general rule, but that doesn't mean that you couldn't, absent some other limitation like the Constitution, you couldn't agree to do it differently?
Yeah, well, Your Honor, I think that it does use the word shall, which this court has at times interpreted to be mandatory. Like I said, I think under the Wolf Mountain analysis of mandatory versus permissive, that this is more of a procedural statute. But even if it's mandatory, I think that it doesn't preclude exceptions. If this is the mandatory norm, it doesn't preclude exceptions. And the Change of Venue Act, Rule 29C, I think contemplate that there are exceptions. There are reasons why we might draw the jury, the prevenir, the potential jurors from a different county in which the trial would be held. So I would say reading, the statutes and rules in harmony as a whole, there's nothing that precludes exceptions from this, even if it is the mandatory norm.
I agree with you that Rule 29C certainly seems to suggest that it's an option to keep the trial in one courthouse or one county and draw the jury from another county. But how do we interpret that in light of the statutes? I mean, obviously the statutes are going to trump the rule, correct?
I think that's the case. If there was a conflict, a rule could potentially be invalid because of a statutory conflict. I'm not sure actually offhand now that.
Does it matter whether it's a procedural rule or a substantive rule? I'm just trying to figure out how to reconcile 107 with our Rule 29C.
Well, I think that here, reading the statute as even the mandatory norm doesn't prevent exceptions. And when the question is whose rights are at stake, our argument is this is the defense in the state. It's not been established as a right to the jury, to jurors, that they have no obligation to travel for voir dire or anything like that. Then I think here, I don't know sorry, to backtrack, I'm not sure the answer about your question to 29C. There's not a 29C motion at this point yet in the proceedings, so that's not directly here before this court. But I think that they can be read in harmony together because the statute doesn't forbid exceptions.
All right, fair enough.
Can I ask one last question about your reference to your petition for extraordinary relief? If you look at 65B, it says that you can seek relief when an officer exercising judicial functions has exceeded his jurisdiction or abused his discretion. So I think you were maybe pointing us there if we determined that she was exercising administrative functions. So I'm just questioning whether that's available under the rule.
Yeah, that's a good point, Your Honor. I don't have the text of that rule in front of me. I think that here I just respond in two ways, and one is that this decision is judicial. I mean, the standing order itself may be administrative, but the order entered in this case was case-specific and judicial. And then the second point is that under the High Country case that we discussed, that this court has supervisory authority and has exercised that even to review administrative decisions, like the assignment of cases.
Thank you.
I have one question that I should have asked you and I'll let you respond. But I'm just curious, since the parties have tried working together and coming up with solutions to a lot of these things. I'm wondering, part of the logistical difficulty is that you're wanting to summon so many jurors. I'm just wondering if it's something that would work if you did virtual jury selection in the beginning until you got to a significant cut of jurors and then finished up with a much smaller number to finalize the jury that was in person. And I don't know if that's something that falls within the standing order because the initial summoning would have happened. And so I don't want to be making the powers that be who are watching this think, oh no. I'm not suggesting that, but I'm just wondering if that's an option and if that is workable and if that runs afoul of this. I feel like I just went boom and walked out of the room.
Well, I can't speak for the amicus. I think that a course like that could be reasonable, and again, we're not trial counsel here, so I don't know all the logistics, but I think the problem here is that the presiding judge didn't allow in-person proceedings at all. So even sort of a initial virtual followed by in-person is not permissible under the court's order.
Okay, so, okay.
At least, I mean, that seems to be my reading of the order, is that she didn't allow in person at all. And then finally, I just note that there is no right to virtual voir dire proceedings. This court ended the mandatory requirement for virtual proceedings, and the third district standing order doesn't forbid virtual voir dire in all instances. So if the presiding judge doesn't view this case as extraordinary, it's difficult to see under what circumstances in-person voir dire could be held in person in the third district. So if there are no further questions, we would just ask that the court reverse these two rulings. And again, if it's possible for this court to issue its ruling by February 21st, it would be beneficial to the time-sensitive nature of the proceedings below.
Thank you very much. We greatly appreciate the briefing, the preparation, and the arguments, and we have well in mind the time sensitivities here. So we'll take it under advisement, and we'll get you something as soon as we can. And with that, court is adjourned.
With all this,